Now, why Armed Forces Special Power Act? Because the state of Nagaland has been declared as a disturbed area by the central government. The Ministry of Home Affairs, issued a notification and declared the whole state of Nagaland as a disturbed area for an extended period of 6 months. Now, why 6 months? 6 months is important because after Supreme Court intervention, the maximum period for which the AFSPA can be declared within a state or a union territory has been limited to 6 months. It cannot be extended indefinitely. There has to be a review period of at least 6 months. So if government wants to impose AFSPA in any state or union territory, it will have to extend it for at max 6 months, and then a review will be done, and if a review finds that another extension is necessary, then only AFSPA can be extended. Now, after the declaration of Nagaland as a disturbed area, these states are now the whole disturbed area in India. The first one is Assam, Jammu and Kashmir, Ladakh, Union Territory of Jammu and Kashmir and Union Territory of Ladakh, Nagaland, Manipur, parts of Arunachal Pradesh. Okay, parts of Meghalaya were also declared as a disturbed area. The areas that were along the Assam border. Okay, so now very important as to whenever we are studying any portion of GS1 or GS2 or GS3, we need to understand the evolution of the law or the evolution of any kind of situation that is present now, because that helps us. Our brain is automatically forming a story. It is connecting the dots, and then it becomes easier for us to understand, and it becomes easier for us to retain the knowledge that we gain. Fine. तो 1958 में सबसे पहले Armed Forces Assam and Manipur Special Powers Ordinance was brought. It was a presidential ordinance. It was not an act in the beginning. In 1958 itself, the Armed Forces Special Power Bill was brought, and it was passed in both Lok Sabha and Rajya Sabha, and it got the assent of the president and became an act. In 1972, amendment to the act. This was a very important amendment, the amendment that was brought in 1972, and it brought the power of declaring a disturbed area or extending AFSPA to any state or union territory to the central government also. That means the original act of 1958 did not have the provision that empowered the central government to impose AFSPA. That is a very important consideration that we need to take here from. ठीक है, तो okay, तो 1958 में जो ओरिजिनल एक्ट था, सेंट्रल गवर्नमेंट did not have the power. Now, if the central government did not have the power, how it was done? If we read the section 3 of Armed Forces Special Power Act 1958 as amended in 1972, we will observe that originally the power to declare a disturbed area rested with the governor of the state, not even the state council of ministers, not even the chief ministers, but the governor of the state. Now we understand that unlike the president, governor has specific discretionary powers, not only constitutional discretion but situational discretion as well. And we understand that the discretionary power of governor is higher than that of the president. President does not has any kind of discretionary power, okay, that except for inviting someone to form a government. President has only one discretionary power, and that is he can invite, in case of a logjam after the elections, he can invite anyone to form a government. That is only discretionary power a president has. Okay, but governor has certain discretionary powers. For example, the governor can send a report to the central government. Okay, the governor can send a report to the central government regarding the failure of constitutional machinery within the state. Okay, that is an important discretionary power. Now second thing we try to understand is the federal aspect of the governance of the country. Why? Because the power of extending emergency to the state or declaring presidential emergency within the state, of course, hampers the federal structure of the country. Okay. Similarly, in a situation of national emergency, we observe that the whole governance of the country becomes unitary in nature. Although the state governments are not suspended, okay, even though the state governments are not suspended, still the majority of the power rests with the central government, and central government can enact any law within the state domain as well. Not only the legislative competence but also the executive powers of the state are get concurrently transferred to the union as well. Okay. Now, similarly, the extension of Armed Forces Special Powers Act, when the central government gets the power to declare an area within the state as disturbed area, this is an act of superseding the federal structure. Federal structure means that states are independent constitutional bodies. Okay, a center is an independent constitutional bodies. Okay, both are independent constitutional bodies made by the constitution itself. Okay, state governments are constitutional bodies. Okay, state legislature is a constitutional body. Governor is a constitutional post. President is a constitutional post. Parliament is a constitutional body. Okay. But important thing is कि जब हम फेडरेशन में, ओके, जब किसी भी एक यूनिट ऑफ गवर्नेंस, फॉर एग्जांपल सेंटर, becomes overpowering, then that is called the breach of federation. Okay, but we also understand that India is not a purely federal country. India is a quasi-federal. Quasi-federal, that means it is a federal country, but with sorry, with unitary bias. Okay, it is a federal country with unitary bias, and that is a provision of constitution itself. Now, when now Armed Forces Special Power Act, it has been in news not only for the breach of federal aspect of the governance, but also for the crimes and atrocities committed by the armed forces as well. Okay, so there has been certain movements within the state of Manipur regarding the atrocities committed by armed forces. Okay, so it has been constantly in news for the human rights violation or for the breach of federal aspect and all these things. So as a civil servant, when a question comes in the mains, so what you have to do is you have to balance the legitimate right of the state. Okay, the legitimate right of the state. Okay, there exists a moral dilemma. Okay, what moral dilemma exists is कि the state has the legitimate right. State, okay, state here, not only the state government, but state means the ruling authority or the central government or the state government, both. Okay, the one who controls law and order. The state has a legitimate, okay, legitimate right, okay, legitimate right of preventing secessionist tendencies. Okay, the state has the legitimate right of preventing secessionist tendencies. ठीक है, मतलब स्टेट का प्राइम राइट है, लेजिटिमेट राइट है कि वो अपने स्टेट के को टूटने से बचाए. Okay, state has its legitimate right. The second point that we are taking is कि the people have right of self-determination. Okay, right of self-determination is also accepted, or it is a provision within the United Nations Convention on Human Rights, UNHCR. ठीक है, तो यहाँ पे एक conflict हो गया. This is a moral dilemma. ठीक है, for state. This is a moral dilemma for state. तो यहाँ पे when you are writing an answer, you will have to take a balanced approach. Your answer should contain the representation of the rights of the people and the acceptance or the proposition that state also has the legitimate right to prevent the secessionist tendencies. Okay, and such topology, such approach can also be used when answering the questions of moral hazards within the ambit of ethics. Okay, when there is a question regarding the violation of human rights and the state the role of the state and all these things. So you can use this approach. Okay, then you can form an answer जहाँ पे आप mid approach का use कर सकते हैं कि at the end you can conclude that a convergence of both rights of people of self-determination and within the aspects of the national sovereignty. Okay, तो इन सारे points को national sovereignty और people की individual sovereignty को mingle करके एक national identity develop करने की कोशिश करके एक आंसर बनाया जा सकता है इस तरीके से. Okay, that is how we are going to take the mains aspect of these questions. Now, power to declaration of disturbed area. As I told, the original act of 1952 or 58 did not have the power where the central government can declare any area disturbed area. But after the amendment of 1972, central government also was empowered to issue a directive declaring any area as disturbed area. So who has the power? The governor. In a case of state, the governor can issue notification in the official gazette of the state and declare that such and such part or the whole state has been declared as a disturbed area. Okay. State government can also recommend or request the governor or the central government as well to declare some part of or the whole state as a disturbed area. Now the second point is for a union territory. Union territory के लिए the administrator of the UT or the central government both can declare the whole UT or the parts of UT as disturbed area. And for central government, the power of central government extends within the territorial boundaries of the country. Okay, territorial boundaries matlab union territories as well as states. But very important point to consider here is when you say Union of India, the Union of India and Territory of India both are different. Okay, there's a specific difference between Union of India and Territory of India. So what difference is that? Territory of India includes all the territories of union government. Okay, whereas Union of India is a union of states which forms India. Okay. Okay, power of armed forces now. Any person, the first one is fire upon or use of force. The armed forces can fire upon or they can use force. For what? They can fire upon any person of the armed forces. That is a controversial point. Why? Because any person of the armed forces, whether he is a commissioned officer, okay, commissioned मतलब लेफ्टिनेंट और ये सारे रैंक के जो ऑफिसर हैं वो, नॉन कमीशनड ऑफिसर, ठीक है, नॉन कमीशनड ऑफिसर, द पीपल हु आर नॉट कमीशनड आर नॉट कमीशनड मतलब बेसिकली जूनियर कमांडिंग ऑफिसर्स एंड ऑल, ठीक है, कमीशनड ऑफिसर, नॉन कमीशनड ऑफिसर, इवन कॉन्स्टेबलरी, ओके, ठीक है, even the constabulary can open fire on people if he believes that, if he has enough reason, yeah, sufficient reason to believe that the people can create chaos, okay, that people can disturb the peace of the area, okay, after giving due warning. But important point is he will have to give due warning before opening up the fire or using the force otherwise. Okay, the second point is he can destroy what? Destroy arms dump, yeah, any training area, even he can destroy any tent, okay, any housing facility, okay. Now arms dump मतलब अगर आर्म फोर्सेस को कोई आर्म्स डंप मिलता है जहां पे बहुत सारा हथियारों का जखीरा है, तो दे कैन डिस्ट्रॉय दिट, ओके, एनी ट्रेनिंग एरिया, ओके, लाइक लश्कर तैयबा का कोई ट्रेनिंग एरिया या उल्फा का कोई ट्रेनिंग एरिया, टेंट, एनी हाउसिंग काइंड ऑफ accommodation or any place that was used for accommodation, if the armed forces has reason to believe that these training areas and these tents and these areas can be used to train people to incite violence, okay. Enter and search any premises without warrant, okay. Criminal Procedure Code mentions that police can only search after obtaining a warrant. If a police appears at your doorstep, you can ask it to provide you with the warrant. If it does not have the warrant, it does not have the right to search your premises. Okay. Similarly, enforcement directorate also can search only with a warrant. Okay. To enter and search any premises without warrant, बिना warrant के search, and बिना warrant के arrest भी कर सकते हैं. Okay. If the person of the armed forces has specific reason या sufficient reason to believe that you are the person who is going to cause disharmony in the state, or who is going to disturb the peace of the state, or the part of the state. Okay, that is how this whole slide determines the power that has been conferred upon the armed forces. Okay, under the Armed Forces Special Powers Act 1958, after the amendment of 1952. Now, protections to the officers of armed forces. Okay, very important point is that since the local police is not a part of the forces that are implementing the AFSPA Act. Okay, the local police is not the part of the force that is implementing the AFSPA Act. The state force is not the implementing force of the AFSPA Act. AFSPA Act को implement कौन कर रहा है? सेंट्रल गवर्नमेंट की फोर्सेस या मिलिट्री या आर्म फोर्सेस जो भी सेंट्रल गवर्नमेंट की हैं. ओके, ओके. तो इंडेमनिटी, इट इज कॉल्ड इंडेमनिटी, इंडेमनिफाई. मतलब what is the meaning of indemnify? Indemnify. This is an important term mentioned under Article 35 of the Constitution, where martial law, Article 34 या 35 में mentioned है कि where martial law is implemented, the government can indemnify any officer for any commission or omission. मतलब किसी ऑफिसर के द्वारा किए गए किसी काम को गवर्नमेंट इंडेमनिफाई कर सकती है. इंडेमनिफाई मतलब the officer can be granted protection under the law. Okay, granted protection okay, from prosecution. That is, if the martial law is in force and certain officers commit some crimes, okay, and when the martial law is removed, okay, then those crimes can be brought into the judicial aspect. But if the government wants, it can indemnify the officer, that is, it can grant protection from the judicial prosecution to that specific officer who has committed any crime within the ambit of the martial law that was implemented at the time of the martial law. ठीक है, तो that is indemnification. ये similar concept है AFSPA के अंदर कि if any central government officer of paramilitary forces, okay, armed forces is committing any crime, so the permission of central government becomes very important, without which you cannot prosecute, you cannot bring any action against the officer of the central government or the armed forces officer who has committed that crime. Okay, मतलब central government की permission लेना जरूरी हो जाएगा if you want to prosecute that specific officer or specific person who has committed that crime within the application of Armed Forces Special Powers Act. Okay, मतलब special central government की permission के बिना you cannot file an FIR against the person of Armed Forces Special Power, the armed forces under the Armed Forces Special Power Act. Okay. Now, judicial interventions are very important. Judicial interventions ही interpretation देते हैं law को, और judicial interventions ही समझाते हैं कि law का application कैसे होगा, right? तो इंद्रजीत बरुआ versus State of Assam, it is a very very important case. ठीक है? It conferred the power on commission, non-commission. It said that the conferment of the power of firing, या power of using the force by a non-commissioned officer is not unjustified. Supreme Court said that if the act permits even a non-commissioned officer to open fire upon a crowd or some person who is trying to create chaos, or when that person has specific reason to believe that person might create some chaos, so that is not unjustified and that is valid. Okay, understood? The second point is the governor is empowered to declare any area of the state as disturbed area. It could not be arbitrary. Okay, but as arbitrary or as vague the wording of the law are, as vague this judgment is. Why? Because it says that the governor cannot declare a part of the state as disturbed area on arbitrary grounds, arbitrarily. But what is arbitrary in nature? It says that there should be legislative guidelines. Legislative guidelines मतलब, फॉर एग्जाम्पल अगर असम का स्टेट है तो असम की जो स्टेट लेजिस्लेटिव असेंबली है वो गाइडलाइंस पास करेगी कि अंडर व्हाट कंडीशंस कैन द गवर्नर डिक्लेयर under what conditions can the governor declare any part of Assam as declared disturbed area. मतलब there should be a legislative guidelines, ठीक है, और एंड उन गाइडलाइंस के विद इन ही गवर्नर जो है डिक्लेयर कर सकता है डिस्टर्ब्ड एरिया. ओके, तो all the states have, most of the states have implemented, most of the northeastern states have implemented legislative guidelines. जहां पे legislative guidelines implemented नहीं है वहां governor is empowered to declare disturbed area as per his own will. Okay. Now Naga People's Movement of Human Rights versus Union of India, इसमें एक important judgment निकल के आया कि Section 3 cannot be construed as conferring a power to issue a declaration without any time limit. जो 6 months का time limit आया, ठीक है, वो इस केस से आया नागा पीपल्स मूवमेंट ऑफ ह्यूमन राइट्स वर्सेस यूनियन ऑफ इंडिया कि द डिक्लेरेशन कैन नॉट बी फॉर इनफाइनाइट पीरियड ऑफ टाइम. द डिक्लेरेशन ऑफ डिस्टर्ब्ड एरिया शुड बी लिमिटेड टू अ स्पेसिफिक अमाउंट ऑफ टाइम एंड दैट शुड बी एट मैक्स 6 months. After the expiry of 6 months, there should be a review. There should be a review of the whole situation of the circumstance of the state, and if it is found within the review that the AFSPA extension needs to be done, then only can AFSPA be extended. Otherwise, it will have to be quashed. Okay. I hope you understood the Armed Forces Special Power Act. Okay. If you have any questions, kindly ask me in the comment section.